Hey, good morning, everyone. Today's session we're going to do is the industrial and intellectual property law. My name is Shazia Khan, and we'll be doing learning outcome 4 today, which is to understand the remedies available for breach of intellectual property law. Before we go on to learning outcome 4, I just want to summarize what we did in the last learning outcome, so you've got an idea of what we did in the last learning outcome, and then this follows on from that. So the last learning outcome we did was learning outcome 3, which was to understand the different types of industrial property rights. So we looked at critically analysing the justifications for intellectual property. We also looked at the advocate case, which is the Irwin Warnick case against Townend and Sons, and the importance of that case in regards to looking at the issue of the intellectual property and what Lord Diplock said in that case. We also looked at the law of industrial designs and how that is different to the law related to, not as much different, but there's a lot of areas that are different in regards to intellectual property. We also looked at the element of how in today's society we have a 3-dimensional, 2-dimensional plan to look at in regards to elements of the shape of a product, the form. We looked at the issue around the standardization. We gave examples of the laws in UK and how it protected individuals, things like, you know, if something's a different shape or a different design and how it's packaged and things like that, why it's important to have these plans in place in regards to that. We also looked at the UK law, national registered design right, excuse me, and unregistered design rights and the relevance of these in regards to intellectual property rights. And we looked at elements of different industrial forms of different industrial property. So now working on from looking at the different elements of intellectual property and looking at the issues that were looking at protected innovation. We're now going to look at elements of understanding the remedies available. So if there's a breach of intellectual property or anything, what are the remedies available for individuals? Because, you know, the law protects intellectual property, but there needs to be something in place that will protect the individual's creation or the innovation. So there needs to be something in place in regards to that. So we're going to look at now on learning outcome 4, which is to understand the remedies available for breach of intellectual property. So firstly, I'm going to go through the assessment criteria with you. So this is the final learning outcome before we go through the assignment discussion. So you'll have an idea of what we'll be doing in regards to the assignment discussion. So 4.1, we're looking at the assessment criteria to evaluate for learning outcome 4, to evaluate the application of sanctions for misuse of intellectual property, including civil and criminal remedies. So it is really important when it comes to intellectual property that it's protected properly, and there are laws in place to protect individuals, and if there is an element of a criminal law or a civil law crime, that the individual is protected. We're then going to look at 4.2, which is to evaluate an administrative mode to apply for or deal with the infringement of intellectual property. So the indicative content, so we're going to look at sanctions of breach, misuse, instinctively property, what remedies are available, the timeline and stages of patent prosecution, and remedies in international context. So firstly, 4.1, evaluate the application of sanctions for misuse of property, including civil and criminal remedies. So intellectual property rights give the right, exclusive rights to the individual. Where someone infringes these rights, there are certain remedies available. Firstly, to identify, intellectual property law protects the rights of owners, while criminal law secures the public interest for harm to the society. In present technology, as everything's changing and there's a driven society, there's so much magnitude of intellectual property violations, particularly in the form of counterfeiting. So, people will sell counterfeiting trainers, for example, Nike, they will sell designer clothes, which are counterfeiting, and this affects the general public. And it is our criminal law to ensure the stringent protection of intellectual property. The intersection of intellectual property and criminal law remains controversial, yet significant, and as it is the interest of those to examine the provisions around it. There's a lot of elements of intellectual property, because the changes. In some areas, civil law protection still does not seem appropriate and efficient to the method of to counter the ever-increasing, commercial violations of intellectual property. Intellectual property, as we know, protects the private right of the owner and licenses of intellectual property. And as we know, there's lots of counterfeiting and lots of piracy going on. And there are laws in place to protect that. Infringing that are sold via like e-commerce platform to consumers. It's not just the fact that these are being sold in shops. It's also through the internet as well, Sometimes it's difficult for governments to identify that there's been any sort of intellectual property infringements, but now there are lots of technology and laws in place that could identify if there's been a lot of issues of infringement of intellectual property. So it's really important, that when we look at it, it's a criminal sanction itself as well, and it is a civil sanction. So it needs to be taken in mind when looking at things like that, counterfeiting or piracy or copying. They are forms of infringing the intellectual property laws. So in general, an intellectual property right infringement is a breach of intellectual property right, which is IPR. IPRs are infringed upon when a work protected by intellectual property law is used, copied, or exploited without consent from the owner. As we mentioned, it's work that's been exploited without any sort of consent from the owner. So, if you produce something and the other person copies it, it's a violation of your actual, maybe it might be something that you've invented. It might be a product that you've, it's them lot using your product, with the intention of causing some sort of harm to you, because they're trying to identify that what they're doing is normal, but it's not. Intellectual infringement is a violation, as we said. For example, it could be creating a listing using a third party's image, trademark, logo, design without the appropriate permission from the intellectual property rights. And that can constitute infringement, intellectual property infringement, and the misuse of rights. Copyright misuse occurs when a company, another example, or an individual makes unjustified use of copyright, which is beyond its legal capacity, and in violation of the Copyright Act of the concerned country. So, each country has its own laws for copyright, but, it's abusing that power of misusing any sort of you know, if you're copywriting or misusing anything, it's really important that, you know, the laws are in place to identify that, you know, and it does happen a lot. There's a lot of abuse of intellectual property rights. And an example of intellectual property infringement, another one include counterfeiting, so imitating genuine goods, often at a lower quality. And piracy, that's a big one. And the unauthorized copying, use, reproduction and distribution of materials protected by intellectual property, for example, pirating the film. These are really important in regards to that. So we've got intellectual property rights, which is IPR, which is referred to there, and then we have intellectual property, which is IP, so you don't get confused. So the concept of IPR is not a recent one. It's emergence trace back a long time ago. And the whole point of this was that in the 19th century, there were discoveries and inventions coupled with an increase in the production of, you know, products with the help of new technology. So as new technology was coming in, products were being introduced. And, you know, in 1995, the TRIPS, which is Trade-Related Intellectual Property Rights, signed the aegis of World Trade Organization in 1995, it was. The areas at that time that were covered under that was copyright and related rights. Trademarks included service marks, geographical indications, industrial designs, patents, layout designs of integrated circuits, undisclosed information, including the trade secrets, control of anti-practices and contractual license. Intellectual property, as we said, is abuse, basically a defense for the suit of infringement. With such a defense proves to be justified in a case and the defendant is spared from the liability of granted immediate relief to the plaintiff. However, the misuse doctrine does not prevent the party to rely on the courts in the case for future infringement. So the intellectual property owners may return to the court once they have purged the misuse, for example, by striking anti-competitive provisions in their licensing. So it's really important that, you know, you're able to identify that. Criminal law and intellectual property. So the domain for criminal law So the domain of intellectual property as a private law seeks to protect the creations of human creativity, taking along the concept of proprietary rights. So who has the proprietary rights? Intellectual property law seeks to create exclusive rights in intangible, and like any tangible properties, it subjects tangibles, intangibles to similar rules regarding ownership, protection from evasion, assignment and lease, etc. So, you know, it looks at the elements of this. So there was someone called Herbert Packer he said that it is common to assert there are two conditions to be satisfied before the criminalization of a conduct can be justified. Firstly, when it comes to intellectual property, that the conduct must be wrongful. And secondly, that it must be necessary to employ the criminal law to condemn or prevent such a conduct. So, you know, you have to identify that there was some wrong. For intellectual property violations, the concept of harm plays a fundamental role. Harm can be caused to the interests of the individual intellectual property holder, so the person that actually has the intellectual property, to potential buyers or to societal health and safety. Such harm cannot be addressed merely by application or civil remedies, since it fails to invoke the necessary deterrents towards such acts. For example, when an IP right is violated by the willful use of someone else's trademark or copyrighted work, usually in the course of a business, without the proper authorization or licensing to do so, it is a criminal wrong. The Act is backed by sanction prescribed by the state, and the criminal procedure is expected to be applied to such violation. Here, the willful use may be taken into indicate a deliberate act. So someone's deliberately done that and deliberately using that, not just a mistake or accidental one. And this is deception. So the deception is intentional to defraud the potential user, which causes brand diminution to the intellectual property holders and cheating for the potential buyers who consider it authentic when it is fake. So, you know, you buy a bag and you think it's authentic, it's a mulberry bag, and then next thing you know that it is a fake bag. So, you know, it's a deception and it's a criminal offence with regards to decepting an individual or society. It is clear that intellectual property and criminal law intersect on the periphery of the impact on general buyers and legitimate right holders, for example, as a violation of general public interest. Accordingly, most jurisdictions prescribe penalties for intellectual property violations because they fit the requirement of criminal law in that it inflicts injury, not only on the individual concerned, but as a society as a whole. So if you are selling products and people are believing that they are, you know, they are real, it's affecting the society as a whole. An example here would be that penal provisions can be found in the Trademarks Act 1994, TMA UK, and the Copyright Designs Patents Act 1998, CDPA UK, as well as more recent acts such as the Fraud Act 2006 and the Video Recording Act 2010. Largely, the introduction into national laws of penal provisions is a result of the adoption of TRIPS agreement in 1994, which imposed a minimum enforcement in all member states, primarily to counter the production and sales of counterfeit products and piracy worldwide. So it's happening it's quite a huge thing, because not just nationally within the UK, but internationally, you know, where counterfeit products are being sold, and it is criminal enforcement and a criminal offence. So counterfeit products are generally defined as fake products. So at least bearing in mind trademark, copyright, that is identical to or indistinguishable form a trademark, copyright registered to another party. So like we said, infringing the right of the holder of the trademark. So things like Nike, it could be Adidas, it could be Mulberry, it could be Ralph Lauren. Counterfeiting refers to intentional and calculated reproduction of a genuine article for the purpose of misleading the recipient or buyer into believing that he or she is buying the genuine product itself. In this process, the owner of the relevant intellectual property legal rights, such as trademark, are infringed. As it has been argued, counterfeits not only bring economic loss, but destroy businesses through loss of profits and consumer trust and ultimately brand value. The global losses from the counterfeit market are understood to be hundreds of billions of pounds. Trade in counterfeited goods is now above 5% of the world trade, continuously rising. Its market value in India alone, for example, is 1.17 lakh crore in 2017-18, while in the UK, it is estimated to be 20 billion, huge amount, 2019-2020. Counterfeiting additionally impacts employees, often working under poor conditions in clandestine illegal activities. So it's quite a bit, it has quite a big impact, and it has quite a big criminal law impact as well. So how are intellectual property infringements remedied? So the first one is seize and detest letter. So intellectual properties are infringed upon when a work protected, as we mentioned earlier, by intellectual property laws is copied or exploited without consent from the owner. And examples, like we mentioned, mainly counterfeiting, piracy, reproduction, materials protected, for example, pirating a film. How are infringement rights remedied? So you've got seizing and detest letter. So if someone uses your intellectual property without permission, which happens quite a lot, you can send them an intellectual property seize and detest letter. This letter informs the person using your intellectual property that they are using your IPR, intellectual property rights, without permission and ask them to refrain from using it in the future. Sending a cease and detest letter is the first step in dealing with illegal use of intellectual property rights. Using such a cease and desist letter may help avoid unnecessary costs and delays associated with bringing formal proceedings for intellectual property. The next one is coming to an agreement. So rather than going to court over intellectual property infringement rights, consider coming to an agreement with the infringing party. You can, for example, consider licensing your intellectual property to them. For example, allowing them to benefit from some of your rights in return for a fee. So, you know, you could come to an agreement and say you could use it for some fee, and you would be paid for that. A license agreement enables intellectual property rights owner to authorize another party to exercise some of the owner's rights in the intellectual property while retaining ownership. So the ownership would be yours and control of intellectual property. You may also consider mortgaging, selling, or marketing your intellectual property, or entering into a coexistence agreement, which is, for example, both parties agree to trade in the same or similar market using an identical or similar trademark. The next one is mediation. So if you cannot come up with an agreement with the infringing party, you can consider using mediation. Mediation is a form of alternative dispute resolution, which involves an independent, trained mediator who actually facilitates the communication between the two parties having the dispute with the aim of achieving a settlement or resolution. So the whole point of mediation is trying to come to a resolution and trying to mediate between the parties so that, you know, something can be done before it goes to court. Mediation can be used for most intellectual property disputes, including the infringements on trademarks, patents, copyrights, and designs. And if you need a mediation service, you could always contact the Intellectual Property Office, IPO, who have their own mediation service, which they actually consider that you use that one as well. So bring in a claim. So if you wish to bring a claim for intellectual property infringement, you can do so through the Courts of Intellectual Property Office, IPO. Please note that some of the proceedings can only be brought through the IPO, while others can be brought through courts. Copyright infringements, for example, can only be brought through courts. The courts will expect you to have tried to resolve the disputes, and you know they'd expect you to have gone to mediation before bringing a claim to the court, because the courts always expect individuals to have a form of mediation before coming to court, because they want to try to see that you have resolved the matter without going to court first, because you know that's the first port of call. And if you haven't, the courts would then refer you back to mediation to make sure that you have tried to resolve the matter with an independent mediator and try to come to some sort of arrangement or agreement in regards to that. So now we're going to go on to the remedies that are available. So the courts may award a variety of remedies where your claim for intellectual property infringement is successful. Which remedies depend on the type of intellectual property rights that has been infringed and the specifics of the situation. So they need to be looking at whether the case, you know, the severity of the case, how severe it was before, you know, they award any sort of remedy, because they need to look at the importance of that. So first one on the list is injunctions. So an injunction is the most commonly remedied for all intellectual property infringements. Injunctions are court orders that require named individuals to refrain from doing certain specified acts. And in the case of intellectual property, using the intellectual property right owner's intellectual property. Injunctions can take the form of perpetual, injunctions or interim injunctions. Interim injunctions in emergency measures, which is granted prior to the commencement of or during proceedings to prevent a party from carrying out infringing acts while the case is being decided. And perpetual injunctions are typically granted as final relief by the court, prohibiting the unauthorized use of intellectual property rights. Failure to adhere to these injunctions can result in either a fine or imprisonment. So, you need to make sure that you are following the requirements of the injunctions that are put in place by the courts, because if you do not follow them, you would either get fined or there would be an issue in regards to a custodial sentence or imprisonment for you. The next remedy is damages or accounts of profits. Where a profit has been made as a result of the intellectual property right infringement, the IPR owner may be entitled to compensation. So what the courts will say that is you've made, profit from that. So it shouldn't be yours anyway. It should be the person who's produced or, the intellectual property rights owner, not yours. The courts can award such compensation in the form of damages or an account of profits. The intellectual property owner is typically given the choice between either remedy, but they can only choose one. Damages usually cover the value of damage done to the IPR owner, while an account of profits covers the profits that the infringing party has made as a result of their infringement. So, as you said, I just said that it's either one or the other. Where damages are awarded, the IPR owner, a calculation is carried out as to the amount of profit the IPR owner or exclusive license, for example, someone who's granted the exclusive license to exploit the relevant intellectual property rights, has lost because of the infringement. An account of profit aims to compensate the intellectual property right owner for the loss they have suffered as a result of infringement. Where an account of profits is awarded, a calculation is carried out as to the profits made by the infringing parties as a result of their infringement. The sum awarded under account of profits aim to put the IPR owner back in the position they would have been had the infringement not happened, so insofar as practicable. So they tried to, award them either the profits or either damages would be awarded. So that would be up to the IPR owner to decide that. The next one is awards of costs. An award of costs is a court order stating that one party has to pay another party the cost incurred issuing legal proceedings. An award of costs can either be for the full amount or for a proportion. For example, it might be half or 2/3 of the costs incurred. So, that the cost of court costs has to be paid as well. So this has to be decided between the parties. The next one is delivery and or destruction of infringing items. So while there's no automatic entitlement to the delivery up or destruction of infringing items or materials and items used to make infringing items, the courts may make such an order when infringing is shown. This relief is typically granted by the courts in addition to an injunction. Where an order for the delivery of such items is made, this means that the infringing party needs to deliver to the IPR owner all infringing items, and where deemed necessary, the items used make the infringing items. Where an order for the destruction of such item is made, this means that the infringing party needs to destroy all the infringing items, and where deemed necessary, the items used to make the infringing items. These steps actually ensure that the infringing party cannot continue to use the infringing items. And then we've got tracing orders, and here the courts may also make tracing orders, which order the infringing party to provide information on where they acquired the infringing items. This is generally used where the infringing party did not create the infringing items themselves. Failure to comply with tracing order can amount to contempt of court, which can result up to fines of 2 years imprisonment. So as you can see, it's not something that, you can get away with. There are remedies in place for that, and they are, if you do infringe intellectual properties, and do something unlawful, that you would have to face any sort of litigation, or there would be any sort of imprisonment as well. And remedies, as we mentioned, could be in the form of damages. It could be court orders, where they cease to impound, or destruct your items. So if you do breach any sort of intellectual property infringement, it can have severe consequences for creators and innovators. And it's really important that, you bear that in mind, because, before you do anything like that, so if you do any piracy, any counterfeiting, you need to make sure that you are aware that the remedy available could be imprisonment in some cases as well. So, you need to be made aware that, you are not doing anything in regards to looking at, any sort of form of, doing piracy or copywriting or anything like that, because, you could face a potential fine, a huge fine, but also prison. People may think that they won't be going to prison, but they are. That you could go to prison for that. So, you need to really be careful that you are looking at, the consequences of doing that. And, the remedies available for the person that's you have taken the items from. You have infringed the intellectual property, so you should pay the rights for the individual. So these were some of the remedies that we looked at and why they were important in regards to that. Things like damages, imprisonment, award of costs. Legal remedies are critical in any sort of issues of intellectual property rights. It goes without saying that if someone steals something from you, and in this case, intellectual property, there are solutions in place. And the right ones make the creator, make sure the creator gets justice that he or she deserves. The sum that are awarded for damages aims to put the intellectual property rights owner back in the position they would have been if the infringement did not happen, like we said. So, it needs to be taken into account. So is intellectual property infringement a criminal offence? As we mentioned, it is typically intellectual property. Is not considered a criminal offence, but rather a civil one. Despite this, but it can become a criminal offence. Despite this, there are some kinds of intellectual property that can result, as we mentioned, in criminal offences, and the one that we're looking at is counterfeiting, which can result in criminal liability, dependent on the severity of each case as well. You need to look at how severe each case. For most part, criminal sanctions only come to play with commercial scale counterfeiting, like big, cases. The patent infringement does not typically fall under criminal liability. This is a consequence of likelihood of accidental infringement and the technical aspect of infringement when it occurs. It's also really, really important to note that whilst intellectual property infringement itself may not result in criminal sanctions, it may bring attention to other activities surrounding that it will. Civil matters are resolved through remedies that are compensatory rather than punitive, as in criminal law. In this way, they're designed to stop and limit damage to the infringed party and restore their financial position. This can include things like legal actions such as cease and desist, which went through injunctions, as well as damages. In order to achieve the best outcome for the intellectual property when enforcing or defending, it's best in that instance to get someone who's a specialist in that area to kind of give you the advice, so that you're able to apply for what you need to apply for, because it is something that's that happens quite a lot now, and as society is changing, there's more technology coming into place. It does happen a lot. As we mentioned, civil remedies provide a compensation to the wronged intellectual property rights holder. Criminal sanctions are often warranted to ensure sufficient punishment and deterrence of wrongful activity. You know, so they both amount to some sort of, you know, elements of compensation or damages being awarded. So 4.2, evaluate legal and administrative mode to apply for to deal with infringement of industry property rights. So in general terms, intellectual property rights infringement is a breach of intellectual property rights. As we mentioned earlier, intellectual property rights are infringed when a work protected by intellectual property law is used, copied, or otherwise exploited without having the proper permission from the person who owns the right. The Copyright Design and Patents Act 1988, CDPA, outlines two different classes of infringing: acts of primary infringement and acts of secondary infringements. Acts of primary infringement are strict liability offences, meaning that no knowledge or intention is required to be shown in the part of the defendant to establish the liability. And acts of secondary infringement require defendant to have certain specified knowledge or reasonable grounds for having such knowledge at the time. So they know what they are doing at the time of the offence. So, you know, they need to be taken into account. If a person does any of the following acts in UK without consent or license of the copyright, he's committing a primary act. So things like copying a copyright work, issuing copies of the copyright work to the public, renting or lending the copyright work to the public, performing, showing or playing a copyright work in public, communicating the work to the public, or making any adaptation of a copyright work or doing any acts in regards to adaptation. Acts of secondary intellectual property are things like importing it into the UK other than the importer's private and domestic use, in the course of business, so possessing, exhibiting in public, or distributing it as well, selling, letting for hire, or offering or exposing the sale of it, distributing it other than the course of business, such as prejudicially affect the copywriter's own. As we mentioned earlier, the defences and remedies available for this in regards to the misuse of property, misuse of intellectual property. So, you know, it could be a number of permitted acts with businesses may be doing things like, you know, fair dealing, criticism of the review. So, you know, you need to follow the Copyright Design Act, Patents Act 1980 out in regards to primary and secondary infringement. So civil remedies available for intellectual property. Again, we went through some of them: injunction, damages, account of profits, which we've been through as well, and return of destruction or infringing items, and then tracing orders. The timeline and stages. The timeline and stages of patent prosecution. So getting a patent can take 2 or 3 years after you file your application. This process, which is known as patent prosecution, may become longer and more complicated if the patent faces opposition, or if the US Patent and Trademarks Auditor asks for more information. So for most of these inventing in the UK first filing is often the place to start. It has a relatively inexpensive official fees and plans your flag in the sand for further applications. It is important to know that a UK application only provides protection in the UK, plus some of territories if applied for re-registered. After filing, the main stages of patent prosecution are search, publication, substantive examination, and grant. After grant, renewal fees need to be paid in the UK Intellectual Property Office, which is IPO, to keep UK patent alive. The time it takes for a patent application to grant is mostly dependent on how long it takes for the IPO to examine your application and how many rounds of correspondence it takes for your application to reach an allowable state. However, It is worth knowing that the UK has a compliance period, which is 4.5 years from filing date or 12 months from the issuance of the first examination report. This sets the period in which the application must be put in order for a grant. In brief, the search needs to be requested during the first year after filing your application and is where a patent examiner searches for worldwide public disclosures to determine whether your invention is a new one and is inventive. The search results are communicated to you in a search report. The search report is usually provided to you before your application publishes and can be useful to decide if you want to continue with the application or if you don't want to continue with that. Publication happens around 18 months from filing the application, and publication is when the world is informed of the content of the application and therefore how your invention works. At this point, you start to get some provisional protection from third-party infringers in the UK. If you don't want the world to know about your invention, let the attorney know about that at least a couple of months before the publication date, so you can withdraw your application and stop application process altogether. By 6 months after publication, around 2 years from filing the application, substantive examination needs to be requested, if not done so at a filing stage. Substantive examination is the bulk of the patent prosecution in the UK and is where the patent examiner decides if your application meets the requirements of the UK's Patent Act. So it's quite a rigmarole process to go through, and this involves determining if your invention is novel and inventive, as well as addressing any other objections, such as whether your claims are clear or if you have sufficiently disclosed your invention in your application, or if during amendments to the claims, for example, you added subject matter since filling your application. Usually there are at least a couple of rounds of correspondence so sent back and forth between yourself and IPO to negotiate the best allowable scope of protection for your invention. Once all of these matters arising during the examination have been addressed, your application then proceeds to grant. At this point, you can celebrate your successful application and that you can now also exploit your monopoly against third-party infringers in the UK. So the UK application timeline, patent prosecution timelines and stages. Remember, you're choosing your route for a patent application will depend on your invention, your business plans, your available funds, and your intended market, and the likeliest sources of infringing products. So these are things that need to be taken into account when you look at the stages of patent prosecution, and why they're so important in regards to identifying any sort of elements. So, there has to be a timeline, and it's quite a lengthy timeline. So it could be up to 4 years. It could be longer in some stages as well, dependent on the severity of the case, because each individual case is separate, and each individual case can take up to 4 years or longer in some cases. So, it has to be something that you are aware of, that, it's not something that can be done straight away. So, it could be a lengthy process. Remedies in international intellectual context. So the Hague Agreement is an international registration system which offers the possibility of obtaining protection for up to 100 industrial designs in designated member countries and intergovernmental organizations referred to as contracting parties. By filing a single international application in a single international application, single language, either directly with the International Bureau or of the World Intellectual Property Organization, or indirectly through the Office of Applicants Contracting Party. Now, intellectual property is a territorial in any given country. In most countries, the first file system exists, so act early before someone else does. So getting IP intellectual property right varies from different countries to country. So your patent or design may not qualify for protection in all markets that you're interested. So, it's really important because other countries have their own intellectual property laws, and this can differ from significantly in some circumstances. International treaties provide some uniformity, but their application depends on how the treaty is interpreted, what type of intellectual property is involved, like is it a patent, is it trademark, is it copyright, etc. So it is up to the country abroad who have their own intellectual properties laws granted. Usually protection of copyright work abroad will automatically, in the same way UK protection works. The UK is a member of several international conventions in the field of copyright, and like the Berne Convention for the protection of literary and artistic work. So it depends on their own, laws in their countries. Territorial effect. So the territorial effect of an injunction made by English courts is limited to England and Wales, but such orders can also be registered in the courts of Scotland and Northern Ireland to give effect to them. Unlike courts in the Netherlands and Germany, English courts have been reluctant to hear claims in respect of infringement of a bundle of national patents flowing from the same European patent application. Coin Controls Limited and SUSE International UK and others. A patentee with a bundle of national European patents currently has no option other than to enforce them on a country-by-country basis. And the case in regards to that is a European Court of Justice decisions in GATT and Loop and Roche and Primus in regards to enforcing intellectual property rights. So in criminal cases, so criminal remedies we looked at a little bit earlier as well. We'll just reiterate that. So in criminal cases, there's no right to damages as such. However, under the Proceeds of Crime Act, which we looked at 2002, it's possible to seek a confiscation order. The effect of making confiscation ordered by Crown Court is the defendant's assets, where the proceeds of crime are confiscated. If we're looking at the different elements with regards to, intellectual property and the intellectual property abroad in the international context, the World Trade Property Organization, WIPO, provides a list of national IP offices for businesses looking to protect their international intellectual property internationally. So, it's protecting and managing your intellectual property abroad can be very complex. If you plan on selling, distributing, manufacturing, or sourcing your products abroad, you should seek help from a professional intellectual property advisor, because the issues can be complex if you look at the laws in regards to, international, because they have their own laws. It's not the same as UK law. There will be some treaties, and there will be, like we said, there will be treaties like the Berne Convention in place that will protect them. But it's difficult because it's complex. And the EU seeks to improve the protection and enforcement of intellectual property rights in third countries by having an effective regime. The EU adopted a strategy for enforcement of intellectual property rights in third countries, and that includes things like specific measures to address intellectual property protection enforcement problems. Also, the EU is part of the World Trade Organization and the World Intellectual Property Organization to help improve protection and enforcement of intellectual property rights. The EU is a key supporter of the Agreement of Trade-related aspects of intellectual property, which, as we mentioned earlier, TRIPS. The EU negotiates and has already concluded a series of bilateral trade agreements, which include comprehensive intellectual property rights and, the protection to the EU in regards to them. The EU's current strategy to enforce intellectual property rights in non-EU countries has been in place since 2004, and the objective is to promote better intellectual property standards in non-EU countries and stop trade in intellectual property rights infringing goods. The Commission regularly conducts service of enforcement of intellectual property rights and looking at things, like counterfeiting and piracy. help the EU's counterfeiting and piracy watch list, which it has a watch list that identifies marketplaces outside the EU where counterfeiting, piracy, or other forms of intellectual abuse are common. So, you know, they are looking at intellectual property from a geographical perspective, but they are protecting individuals' rights as well, which is an important thing. And if the rights are breached, there are laws and regulations in place that will protect individuals and protect the EU, such as Regulation 386/2002, which was set up the European Observatory on Infringements of Intellectual Property Rights. So there are laws in place to protect individuals' rights and also protect EU rights as well in an international context. The cost and advantages of private prosecutions. So for a claimant to recover his costs of a civil case, he must be awarded his costs by the court, and the defendant must have the money to meet his obligations under the court order, and his must actually pay the money over. In state contrast, the claimant's costs, win or lose or bring a private prosecution in respect of indictable offences, are recoverable from central funds pursuant to the Prosecution of Offence Act 1985, Section 17. The test for recovery of the prosecution's cost is not whether the claimant has won or lost any of the majority of the issues in dispute, but the much lower standard of whether the prosecution was properly brought. So it's really important when you look at prosecuting someone, you are aware of the laws that are placed. Intellectual property, like we said, refers to the creation of minds, inventions, and businesses are often unaware of these their business assets, including their intellectual property rights. So it's really important, both nationally and internationally, that you are aware of your intellectual property rights and how you can protect them. If you have, want to trade with different countries, you need to make sure that, you have protection in place, but also the intellectual protection are built into the agreement, and that if you're trading with any sort of countries in the Europe or trading with any sort of countries in America, or, they have their own laws in place and their own territories have their own laws in place. So in conclusion to intellectual property, looking at the remedies and the sanctions and international context, protection of intellectual property assets starts long before an infringement occurs. Organizations with approved patents or with an approval pending are considered more valuable. Increasingly, especially in the tech sector, the filing of patents is crucial to securing ongoing funding required for growth. Enterprises need to practice due diligence to understand which intellectual assets that currently have and which are being created. Intellectual property assets driving increased valuation require adequate and robust protection. By ensuring your intellectual property is adequately protected, infringements can often be dealt with more efficiently and cost effectively. So, they could be dealt with quite quickly, but, they wouldn't have to go to court and it wouldn't go further. Intellectual property infringement can have severe consequences for creators and innovators, not just for one person, it could be for both, especially, it could be a large form of compensation or it could be a prison sentence, depending on the severity of the case. Understanding the concept of intellectual property infringement, knowing how to stop unauthorized use, and being aware of available remedies are crucial in protecting your rights. So, it's really important as an individual that you know what your rights are, and that if you, not just in the UK, but any other countries, it could be, intellectual property in maybe countries like India, China, Brazil, but India is quite a high element of, piracy and counterfeiting. And if if there's intellectual property theft, that's an important thing, and it is growing within that's dishonestly trying to appropriate any property belonging to another person. So in India they have laws in place, things like copyright laws, copyright acts. So, you need to bear in mind when you're looking at the laws of the country, they are different to the laws of the UK. The final slide here is a link to Europa Link, and it looks at an article, and it looks on infringement of intellectual property, and it's quite an interesting one, and I've put a link on there for you to look at. Just click on that link and it'll take you straight to the article for additional reading that you can do to help you support for your assignment. And these are the references that we've used for today's session. So there's quite a large amount of references there that you could refer to in regards to trying to get your assignment done, or reading around things like, infringement of intellectual property, or any sort of issues around remedies or sanctions, and criminal and civil infringement. So these are some of the references, some good books there as well. Please refer to the article, the link that I've put there. It's a good article on infringement rights. And if you have any questions, please email learnerwork@ukvarsity.co.uk, and also go on to Moodle for any additional reading. The resources will be available on Moodle for Learning Outcome 4, for all the learning outcomes, so make sure you go onto Moodle for that. Thank you. This is the end of Learning Outcome 4. The next session is assignment discussion, and thank you for attending today's session. Thank you.